Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. Well, let me make one confession today. I've always had a bias towards lawyers who pursue masters from top Ivy League universities in the world, be it Harvard, Oxford, Cambridge, and Yale, to name a few. So joining us today on the Virtual Amicus is someone who needs absolutely no formal introduction in the field of arbitration. He's someone who's not only pursued BCL Masters from the University of Oxford, but went on to do a PhD from NLU Delhi. Now, everybody knows how hard it is to secure admission at these top Ivy League universities. So we'll be interviewing today one such illustrious alumnus from the University of Oxford in conversation with Dr. Shashwat Bajpai, who's the founder partner DRSB Law Chambers. And just to give you all a brief introduction about our amicus for today's session, Dr. Bajpai is a lawyer hailing from New Delhi, India, and the founding partner of DRSB Law Chambers. He has completed his master's degree BCL from the University of Oxford, UK. He also holds a PhD degree from National Law University, Delhi, which is NLU Delhi, India. He is also been admitted as a fellow with Chartered Institute of Arbitrators, a fellow with the CIARB UK, and he's also on the core committee of the YMG, that is Young Members Group, Chartered Institute of Arbitrators India. He's also the ICC YAF representative for South Asia region. He's also been part of several arbitrations and litigations and argues regularly before the arbitral tribunals and Delhi High Court on disputes pertaining to the EPC construction issues. He's currently on the arbitrator panel of Delhi International Arbitration Center and has presided over as the sole arbitrator under the administration of DIAC as well as Delhi High Court appointments. He's also on the panel of PSUs, oil and gas corporations, and construction companies, representing them in their claims before the courts and in arbitrations. He has several reported judgments to his name and speaks on various topics at seminars and training workshops and addresses several public forums as well. So thank you so much, sir. It really means a lot, your presence on my channel. I mean, mission accomplished. I really wanted to get you on channel someday, and I've been able to do that. Probably my persuasive skills are, something that is paid. Anything that you wish to say about our channel before we start with your Q&A session, sir?
Lovely, Jay. Lovely. Good morning to all the viewers, and I must thank Jay Lodha for inviting me on this wonderful platform that he refers colloquially as virtual amicus, and it's a very well thought out name, I must add, because his reputation, of course, precedes himself. Everyone knows about the channel. A lot of my colleagues have spoken about him. It so happened that I was literally playing a game of idle ball with my colleagues when I was, the channel was highly spoken of, and my wife as well has been part of the channel. So I think it's an excellent platform, not just to interview. I won't say good lawyers like me because that will be praising myself, but with other good lawyers that you've interviewed, but also that I've seen some of the very good videos that are there where the topics are being discussed at length and from a very basic pedestal they are being discussed. So anyone who wants to get a basic understanding of the subject, some of those subjects which have been discussed on virtual amicus, is really good for the students and even for fresh lawyers coming out of the law school. So I must thank you, Jay, for having me here. I think it's good to be a part of an excellent platform that you've initiated.
Grateful, sir, for all the kind words. Really means a lot to me. And to all the viewers who are watching, the topic that we've chosen for today's session is the game of arbitration. That's really a very interesting topic. So, sir, if you're ready, we can quickly start with the Q&A segment.
Yes, please go ahead.
So, question number one, sir, coming your way. What do you mean by the game of arbitration, and why are you referring to arbitration as a game?
See, Jay, it's a more colloquial way of putting it. Basically, like any other popular game, everyone wants to get in on the action. That's arbitration today. And that's one way of looking at it. The other way of looking at it, it's like a seesaw with different, stakeholders always fluctuating between its upsides and downsides of different platforms. There'll be people saying arbitration is excellent today compared to litigation. Some of them will be saying, no, 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 litigation is always better, arbitration has XYZ reasons. No. So it's constantly fluctuating. And it's a game because everybody wants in. I have not seen anyone not talk about arbitration, notwithstanding their field. There may be some tax lawyer, there may be some IPR lawyer, So it's not a field of law. It's a game for me. And it has come, leaps and bounds since last few decades. I mean, since the Act's inception in 1996, now it's what, 28 years, 6 years. And it's really come about as a different, genre and category of laws as, we have thought about it over the years.
Very well, sir. Now, going ahead with our next question. How have domestic arbitration standards evolved over time, and what key trends or advancements are expected to shape the future of arbitration in India?
See, that's a good question. The way it works is that domestic arbitration for, an Indian lawyer is very different from what an international arbitration would be. And what I've referred to in some of my other, speaking assignments, or what we as lawyers, arbitration lawyers in the community have referred, that international standards are something which we need to follow. I'm not saying that, following is good or bad. I'm not commenting on that. But why? Because arbitration, unlike in India, has had deeper roots comparatively in other countries and other institutions like UK, Singapore, all these. So we need to emulate some of those standards here in order to ensure that there is some advancement. Picking up small things like the Amendment Act, we're going to talk about it in a bit. That the important pedestals which the Indian arbitration have to take as launch pads to try and come up to the level of international arbitration. And some of them have been done in the amendments to the 1996 Act. The Arbitration Act is completely revised in 2015 with the mega amendment. And I would feel that these are the advancements which are expected to shape not just the future, but has already shaped the future today. And the reason I say so is because every time I have, literally a call or a virtual meeting with any of my arbitration colleagues and counterparts in other countries, they themselves come up with the answer that now India is quite changed. And unlike in the old days when nobody wanted to come for arbitration in India, it may be a simple arbitration, it used to go for decades and years. All that has changed. So definitely, these advancements got about both by the judiciary and by the legislature, because the legislature in its amendments has carried out, similar amendments which have been given across the world, and through the judgments, which have really paved the way for a good future of arbitration in India.
Fantastic, sir. Now, question number 3 coming your way. How
Mm.
does India's Arbitration and Conciliation Act align with international standards, such as those established by UNCITRAL?
Right. So the way it works is, thankfully, Indian arbitration law is fully modeled on the UNCITRAL law. In fact, most of the provisions are actually a carbon copy of UNCITRAL, which is very good, because not only does it help with a standard form that the India also has compared to other countries, it also helps with any other country. There are two, jurisdictions working on an arbitration, and one jurisdiction will be India. There'll be another jurisdiction which is not India, which is UK or some other jurisdiction. And when they apply UNCITRAL, we know what we're talking about. Why? Because the Indian Arbitration Act itself has provisions which are modeled on the UNCITRAL law. So see, the way it works is in arbitration, as all arbitration lawyers and stakeholders know, that UNCITRAL and New York Convention, these are the two bedrocks of international arbitration. One, the former deals with the conduct of arbitration, the proceedings, etc. That's UNCITRAL. And second, which is New York Convention, which we call 1958, which is enforcement for awards, respectively. India modeled one and is a signatory to the other. So, in a way, India is in line with the arbitration standards as far as the standard form of contract, standard form of laws which are prevailing in all countries. That is something which we should have aligned. We have aligned, because if you remember the 1940 Act, when the 1996 Act came, the first thing we did is, please, let's follow UNCITRAL. 1940 Act was a good act. It was having some basis for an arbitration, but it was so it was decades apart from what the actual law was. And of course, now with the 2015 amendment, it has completely reshape the law for us. So, yeah.
So now, how has the Indian judiciary played a pivotal role in shaping India's development as a global hub for arbitration in the last decade?
Jay, I think that's an excellent question. And the reason is because undoubtedly, the courts have been instrumental, if I may say so, in carving India as an arbitration hub. And I don't say that just because of the judgments that they pronounce. I'll come to some of those judgments. But also because the perception has changed. Earlier, the perception was that an arbitration in India will take years. It will be cost. It'll be not cost effective. Hundreds of demerits, hundreds of downsides were being pointed out. Now, in the last decade and a half, not just I'll come to 2015 amendment later, but even pre 2015 amendment, lot of decisions by the Supreme Court, high courts across the country have actually led us to believe and led the world to believe that Indian arbitration has as good standards and as high standards as any other country. Let's talk about some of the examples of court decision that we talk about. Section 34. Now that's a pivotal section under the Indian Arbitration Act, which talks about setting aside of an award which is given. And same applies to section 48 when we're talking about international arbitrations, international commercial arbitrations. The courts have very well stipulated that this is a narrow jurisdiction which is supposed to be exercised. There are umpteenth number of cases by the Supreme Court, high courts across the country, which have clearly stipulated at least, if not 100, 200, maybe more, 500 judgments, maybe more, clearly carving out the exceptions within which the narrow jurisdiction of Section 34 works. And why is this important? And this again relates back to your question that how is the Indian judiciary worked for treating India, as a global hub in arbitration? Because if I have a client in India, who has his parent company somewhere else, of course, it's an Indian client, it's an Indian subsidiary. It's working with another Indian subsidiary in India, and both get into a dispute. Ultimately, it leads to an award. Now, that award is a well-cited award, well-crafted award. If the Section 34 jurisdiction, which is the only way that you can set aside such an award, had an expensive, would have had an expensive jurisdiction, but for the judiciary, then nobody would start having arbitration clause in India. Simple. So therefore, what was essential is to say that award is final, binding on the parties, except for very narrow few points, which, if taken, will go. You have BGS, SOMA, you have so many judgments which categorically state that if you don't fall within that narrow set A, B, C, D, public policy, etc., patent illegality, etc., all those clauses, all those aspects, all those provisions, then an award is final. So that is something which, the jurisdiction of Section 34 has been instrumental, in treating India as an arbitration hub. You see some other cases also. You see the recent case of the stamp duty case. It was a huge furore. I mean, for the first time, there is a 7-judge bench that was constituted to undo, unfortunately, the 5-judge constitution bench judgment, which was passed on the issue of stamp duty, that if a uh, agreement is not stamped, it does not exist under the Stamp Act. Now, looking at the practical aspects, Supreme Court, in a suo motu exercise of jurisdiction, actually immediately sought to have a 7-judge bench constituted, looking at the practical angle. Now, this is judiciary being instrumental. This is judiciary being, overzealous. I won't say overzealous, actually being good, nicely zealous to, come up with a solution looking at the practical aspects, hearing from the stakeholders. There were several articles written. There were several stakeholders, in conferences, etc., discussing this, the NM Global Mercantile case, where it clearly stipulated that, at that point of time, it stipulated that if you've not got a contract agreement signed and stamped well, if it's not stamped, that agreement will not be taken into effect and you can't go into arbitration. Now, that was a huge, blow to the existing arbitrations, to the upcoming arbitrations, because it's more of a procedural aspect. With all due respect, you can always rectify it, and that's what the 7-judge bench said. So this is another example of how the judiciary comes to the aid and rescue. And judiciary is also instrumental in putting us higher in not higher, placing it similarly to the other international jurisdictions with the international laws and issues. For example, Cox and Kings. Now, Cox and Kings basically, what does it do? Recently, the judgment has been passed. It affirmed the application. There were a lot of judgments earlier as well, which clearly talked about, the group of companies doctrine. Now, it affirmed its application, which basically is what? Which basically it binds the non-signatory companies to arbitration agreements. If they're part of the same group, they may not have signed it. There are 4 or 5 companies, and ultimately they're transacting with a different company. Now, one company has a contract with another company having an arbitration clause, but that same company has other similar companies on the same issue and same consolidated matter having uh, contracts with the other client, but they don't have arbitration clause. Now, group of companies doctrine says if one party is go to arbitration for the same issue, there is no point of having those other technically non-signatories to go for litigation. That will be multiplicity of proceedings. So another excellent judgment which puts us at par, with the international setup, because that's the international setup that's followed. It what it does is this basic doctrine, this is an international doctrine, is based on the idea that group companies are a modern reality of business. It's not just one company that's working. It's effect of group of companies, and a modern approach, is needed to determine consent. So arbitration is all about autonomy of consent. Group of companies doctrine slightly deviates from that. So technically, the other group companies have not consented to arbitration, but they will be asked to join the arbitration. Again, of course, economic reality, consolidated case, of course, there are different stipulations laid out, but that is something. Now, again, when I talked about international, India being an arbitration hub, recent judgment of PASL win versus GE Power Construction. Now, that is also an excellent judgment. Why? Because therein, it accepted the view that two Indian parties can choose a foreign seat. Earlier, there were a lot of different judgments and there were a lot of conflicting decisions wherein the issue was not proper, I would say, not properly dealt with at that point of time. But PSL Wind, the Supreme Court, very categorically stated nothing doing. India is an arbitration hub. If two Indian parties want to have an arbitration, which is a UK seated arbitration, Singapore seated arbitration, there should not be a logjam to it. There's no reason for it. And that's another excellent judgment. There's several aspects. I'll probably take hours and hours to discuss this, but these are few judgments. In fact, modification of award. Now, again, a very important judgment. I think it was NHI versus Hakim, Project Director Hakim. Now, in that, the court held that the courts do not have power to modify an arbitral award. I think that's an excellent judgment because, again, there are two parties, Indian parties, where one have parent or subsidiaries, etc. And if you know that the award has been passed, if it's a patently illegal award or if it's against public policy, of course, it gets set aside. But the High Court cannot substitute its judgment, cannot supplant the award. And that is the certainty in the legal process which all the parties have, notwithstanding in India, notwithstanding a foreign party. So these are so many judgments on different issues that, where I would say that judiciary has not just been instrumental, I think it's pivotal. It's acted as a pivotal fulcrum to making India, as an arbitration hub.
Very well, sir. Now, going ahead with our next question. Now,
Mm,
we've already spoken about the Indian judiciary and how it played a pivotal role in shaping India's development as global hub for arbitration. Now, talking about the recent changes in our Indian arbitration laws,
mm,
how have these recent changes that have taken place in the course of time in
mm.
in Indian arbitration improved efficiency, transparency, and India's appeal as a hub for dispute resolution?
See, again, this flows from my last answer.
Yes,
So judiciary is one aspect where we've dealt with how they have carved out
judicial
India as
decisions.
a hub. And legislature has thankfully not been behind. Let's be honest about
Yes.
it. This arbitration is one field where the legislature has worked well to carve out, a good law that stands today. Not 1996 law was a good law; it was based on unset law, but there were several things which had to be amended to keep it up and running with the international standards. Now, 2015, the mega amendment, as we call the 2015 Amending Act, completely got it up to speed with the international standards. For example, again, we don't have enough time to possibly discuss all the amendments to the several small and bigger amendments, which led to it being called one of the best amendments in the Indian Arbitration Act, in any law for that matter. And one of those, for example, was 29A. Now, Section 29A, why do I call it one of the best provisional amendment, one of the best amendments of a provision? Because it reduced the timelines that the excessive timelines that were there in the earlier arbitrations. It stipulated that you have 12 months, which is 1 year from the start of arbitration. And then later, of course, we have Section 23, subclause 4, which now says, you have 6 months for the dispute resolution, for the pleadings to complete. And now the amended Section 29A says that from the date of completion of pleadings, you have 1 year. So it's stipulated a timeline. It's crafted out a single timeline which the parties are bound to follow. So you can't take 10 years. The arbitrator cannot take 10 years. The parties cannot take 10 years. The basic issue against arbitration prior to this amendment and others was that arbitration, with all due respect, the whole purpose was it's an alternative dispute resolution. And if it takes as much time as the litigation, what's the point? There's no point. So I think 29A was instrumental in carving out the correct timelines. And in fact, in later 2019 amendment, again, a smart move, that it has been set aside, it has been further amended to say that this will not apply to international commercial arbitration, because they are a different genre and category. So there, the timelines had to be removed. Again, a smart move in 2019. So the legislature is trying to keep up speed with all the different changes, etc. And not just for international, at an international level, for a domestic level. Let's take the example of Section 9 and Section 17. Now, under the 2015 amendment, Section 9 and Section 17 were put at par. So the arbitral tribunal will have the same powers to grant interim relief as the court. That's an excellent move. Why? Because a lot of pendency happened because some petitions were pending in the court for Section 9. Section 9 is basically the interim relief which can be asked for courts from the courts where an arbitration agreement exists. And it said, I love the three words: before, after, and during. Before, during, and after. So at any point of time, you can approach Section 9, as the court in Section 9. You can approach you're under Section 17 to the arbitral tribunal and actually have practical reliefs granted to you during the course of arbitration. Someone is trying to remove the property or alienate the property or funds. Now, what do you do by the end of the time you get an arbitration award? That property or amount will have gone. So you need the act to give you a mechanism and procedure to get out of this, to try and get you relief in that sort of manner. So I think those are some excellent amendments. In fact, 2019 amendment, now will, in the process of, at least through the amendment, establishing an arbitration council for India. Now that's excellent again. Why? Because it grades the institutional arbitrations, the arbitral institutions. It reduces the burden on courts where to give, whom to appoint as an arbitrator. And Chief Justice of India will appoint the chairperson of the ACI. So of course, in consultation with the government, like any other provision under the constitution, etc. So this arbitrator accreditation, this timeline, all these are aspects where the legislature has the Indian stakeholders, the Indians have benefited, Indian institutions have benefited from the proactive legislature that has worked, especially starting, 2012, 2015, 15 being the huge amendment, of course, and then throughout 18, 19, and now also they're trying to come up with some amendments. So that's good. It's good. Yeah.
Now, sir, next question coming your
Yeah.
way. In what types and kinds of disputes is an arbitration more effective than traditional litigation? And
Hmm.
what factors contribute to its advantages in those situations?
Right. So to understand, the question correctly, how is basically, I would put it differently, how is arbitration better than litigation? And why do I say this? I've been an arbitration practitioner. I've been on some litigations as well. And there is no doubt. I mean, any person who says otherwise doesn't know arbitration well. that it's no more a rich man's attempt at litigation. Earlier, arbitration was always thought, the big companies will get into it, the private companies will have arbitration, where the arbitrators are there. And I've seen over the past, I mean, maybe pre-COVID, I would say, a lot of people have been pontificating, about the downsides of arbitration, which is, I believe, completely unfair to the arbitration setup. Because I, as a counsel, will, with all due respect to the courts, will never ask them to go into litigation. And I don't blame the judges. I don't blame the courts for it. I mean, that's the system. That's the adversarial procedure, process that we have in the courts, where litigations do take time. The judges are extremely kind to be sitting from 10 to 5 and then again working for the next day's cases. But there is so much pendency that you cannot possibly expect them to finish it earlier. And therefore, the alternative dispute resolution, which is what? Which is arbitration. So arbitration done properly will always be more effective than traditional litigation. Let's quickly see the pluses of arbitration. You have the choice of court. You have your arbitrators to define, to uh, settle the disputes. Both parties choose. There is a setup. You can even go to court. Court will appoint the arbitrator for you. So you have the choice of arbitrators. You know that this person will be available on this date for this matter to get over in this much time. The timelines that I just stipulated under the earlier answer clearly define in what circumstances, what timelines will cover and rule the arbitration. Again, procedure. Most time consuming aspect in the litigation is procedure. You want to make a change, you have to file an application. You have to move one left leg before the right leg. You have to move an, arbitration. There are the CPC. It's a great provision. It's been there since the Britishers left us. But that having been said, the 1908 Act does have the procedural rigmaroles, and arbitration does not get bogged down with that. That is something which makes it much more effective. And some of the aspects have also been, some of these issues that have been cropping up earlier also, and even now for that matter, that arbitration is, not cost effective. I feel completely the opposite, especially in the big matters. Arbitrations having 500 crores, 1,000 crores, 10,000 crores worth of disputes, they don't have the time to go through the entire rigmarole of litigation. Now let's compare that to a suit. I don't understand how arbitration is, not cost effective. Arbitration gives you, this is the fee, this is the amount, schedule 4 for domestic arbitration, if you're governed by that. Otherwise, even under normal circumstances, you will choose ad valorem figure, which is equivalent to an ad valorem figure that you pay as court fees for a suit. So obviously arbitration is better, because for that court fee that you've paid, you are not going to get result for years and years. If a matter goes in regular today, everyone knows, we laugh about in the Delhi High Court and other courts, it comes up after 10 years. That's like an FD one deposit, which is going to mature after 10 years. So I don't see a reason why, anyone should say otherwise. I always feel that arbitration is certainly more effective than traditional litigation. Go ahead.
It's like comparing investment in equity with that of an FD. So
True.
there is a risk factor involved, but yes, thanks to all the decisions, judicial decisions, and
Yeah,
everything that has facilitated the working of arbitration in a very effective, cost-effective manner. So that
absolutely.
has
Absolutely.
contributed the litigation landscape. So now, sir, going ahead with our next question, what is the role of an arbitrator who serves on the panel of arbitration centers? And can you shed some light on your experience on the panel of DIAC?
Right, right. So Jay, I've always believed that, I have several ad hoc arbitrations. That's how you differentiate from an institutional arbitration. But having done both, I can very easily say that institutional arbitrations are always better. And that's what you get when you are on the panel of an arbitration center as an arbitrator. And when clients and stakeholders and companies or individuals approach the institution either through contract or post dispute to to a arbitration institution. Why? Because firstly, and more importantly, foremostly, institutional rules give us guidance, procedural guidance. Of course, the act suffices for a lot of issues that crop up, but to streamline it, to quickly resolve it, how to follow it, that is something when institutional rules come into the picture. I'm not saying it's a panacea for all evils. I'm not saying that. But, it surely reduces the coffee arbitrations, as we call it. What are coffee arbitrations? Which goes on for years, which goes on for, you'll meet one day, then, the parties or the judges will say, we don't have time, we'll come after 3, 4 months. That gets reduced. Again, I'm saying it's not a panacea. It may still occur even in institutional arbitration, but it does reduce the option that parties or the arbitrators, with great respect to them, of course, everyone's time held in their own departments, to have an effective, efficient, and early disposal of their arbitration. Yeah, I've been recently appointed by the court in as an arbitrator in the arbitrators panel with the DIAC, that's the Delhi International Arbitration Center, and I've in any case been long associated with DIAC earlier as well. What sets it apart, like other institutions like MCI, etc., is how well organized and efficient it is. What is the procedure? The timelines are defined in this much time. The statement of claim will come, the statement of defense will be done, then the procedures will be reminded. Now, I don't have to, put it in my calendar literally to say what person has to be told or what party has to be told for what arbitration. There are several arbitrations I may miss out. Having an institution helps you with that. You are not going ahead looking at different places to conduct an arbitration. It's conducted at the place. For DIAC, it will be DIAC. MCI, it will be MCIA. Institution centers, they'll have their own rooms and excellent rooms, and small things we don't realize. Institutional arbitrations, if it makes it more effective for small departments, for example, a steno. Now, if I'm having an ad hoc arbitration and I have to find a steno, the parties will have to find a steno. Yeah, you don't have to think about that. The arbitration center will have its own cost for that, of course, but the administrative cost is nothing against what you actually get. A steno, the place is there, the correspondence gets much easier between the parties. So I definitely feel that an arbitration center, institutional arbitration, is better than ad hoc arbitration. And when an arbitrator is serving on the panel of an arbitration center, he's, I would say, and having been on both platforms, both ad hoc arbitration and institution, definitely gives him a much better breathing platform, because he doesn't have to get into the procedural nitty-gritties of it. He just has to hear and pass an award, which makes life much easier for it, especially on the procedural aspects. Yeah.
Now, sir, you've represented various PSUs in oil and gas corporations, not only before courts on one,
Mhm.
but also in arbitration on the other hand. What exactly is the nature of claims? What kind of claims are adjudicated upon before courts and then arbitrations?
Right. So, the way it works is that when you talk about nature of claims, I always feel that construction, infrastructure, and oil and gas arbitrations are a different genus altogether. And in fact, all the big ticket infrastructure matters are mostly enveloped under the arbitration clause. I mean, you'll have several ad hoc arbitrations going on in different, matters, issues, or aspects. But as far as oil and gas and infrastructure arbitration concerned, I believe 95 to 99%, such disputes are within the arbitration clauses. And why is that? Because of two very simple aspects. Because, and this of course comes back to the question, because of the nature of the claims, the amount and the ticket value of the matter is so big that you don't want to get bogged down in the normal litigation setup. You want an early disposal. Second, and why do I say it's a different genus? Because unlike in other normal ad hoc arbitrations for different aspects, you have a dedicated panel of arbitrators for several PSUs. Most of the big infrastructure matters happens between PSU as the employer and contractor as the the other litigant, and it's imperative for them to resolve their dispute, because a lot of these disputes happen during the pendency of the contract and currency of the contract. If it takes 10 years, your highway will be stuck, highway work will be stuck. What will you do? Your oil and gas pipeline would not be there. The marine jetty will not be made. What do you do in those circumstances? So therefore, quick resolution of dispute is something which you get in an arbitration. And for a claim in the nature of construction and oil and gas, it is imperative that you have uh, a redressal which does not take time. And I believe when you ask the question nature of claims, when we talk about the nature of claims for infrastructure and oil and gas, the second aspect which I feel and which puts it apart from other arbitrations, even court matters for that matter, is the differentiating subset, I would say, is the imperative need for presence of a technical member as a one arbitrator. You'll have a panel of three arbitrators, mostly in big ticket jurisdictions, and not a sole arbitrator, because these are heavy matters where you need representation. I mean, you need a bigger panel as a as a arbitral panel. Now, you would want one technical member at least as one arbitrator. Why? Because to understand the architectural aspects, you need the technical expertise of a member, for example, a retired, uh, a railway member if you're talking about DMRC, or a retired engineer if you're talking about some other construction projects. So they, you'll have judges, you'll have lawyers. That's okay. You can always have them. I might as well say it that those are imperatives and indispensable parts of a good arbitral panel to have them. But in a construction and oil and gas, given the nature of claims, it's also important and imperative that you have a technical member as an arbitrator, because that really effectively helps the panel itself for understanding the issues that have been brought before them, and then come to a better judicial decision. Because if you don't understand the technical nature of some of these issues, you can't understand. A simple even the acronyms are, with all due respect, sometimes not understood even by the lawyers who are explaining them, or by the judges who are taking up such arbitration. So a presence of a technical member assists us and removes all the downsides that you have to a specific claim nature of oil and gas arbitrations or infrastructure arbitrations, as the case may be. Yeah.
Now, sir, next question coming your way. In your view, how have technological advancements redefined arbitration proceedings in the post-COVID era?
I think that's one question where both of us will be knowing it. We had several virtual and physical seminars for the same. Now, see, the answer is, and I believe I can say it with some conviction, that VC hearings, virtual hearings, have completely changed the game in favor of arbitrations, and which has been really nailed into our brain during COVID, and of course post COVID. You know, that is one thing which I felt was, I mean, in fact, which we didn't even know was something which was lacking in the infrastructure. Now that we have VCs, I don't believe anyone will say that arbitration has not come for the better. You save time, reduce cost of traveling, getting witnesses from X to Y position, because the venue of arbitration is ABC, getting the three arbitrators for the panel to come into one venue, having all those resources, they get cut out by virtual, especially for the procedural hearings. Literally to come together and say that we can't have the meeting today. I mean, people had to assemble together. That gets changed. So that is something which, technology has really come, the advanced technology has really come to the aid of arbitration proceedings, and really again changed the game for the better, can change the arbitration game for the better. I believe, we always talk about that acronym, I would say, a word that has been doing the rounds, that it's become global. Or global and local, call it local. A lot of foreign arbitrations where the seat is, foreign seat, the Indian parties want to save costs instead of going to those foreign jurisdictions, especially for the procedural hearings. Nowadays, even the final hearings, even the witnesses are examined virtually. So that ways technology has really come to the aid of arbitration and really shortened the jurisdictional infirmities, or the issues that were culminating earlier prior to these prior to the virtual hearings, etc. So essentially it becomes a local, as you may refer it. Yeah.
So, how has the role of institutional arbitration centers evolved over the last decade,
Hmm.
particularly in terms of efficiency, costs, and procedural improvements?
Right. I think this is, something which I answered earlier as well as a
Yes.
follow up to it.
Wow.
That the role of institutional arbitration centers is much better, as I said earlier, also than ad hoc arbitration because their methodology that they adopt is par excellence. And in fact, what I missed earlier, I must say that every institution has their own rules. You take DI, you take MCI, it's got its own rules, which of course adopt everything that the act says, but it streamlines it further. It makes it more well organized and efficient. As I said, coordination between the parties is directly done. For example, DAC. Now, DAC, as I said earlier, also is a very good institution because I've worked with it. Now I'm on the panel as well. Now, DAC has dedicated deputy counsels. So their deputy counsels will do the entire correspondence. And what it does, it resultantly streamlines the entire procedure. So you don't have to look for XYZ place or XYZ steno, as I said, all those aspects, they get reduced. And what is more important, and this is again, I should have said it earlier also, that the more number of good arbitral institutions you have, the more it showcases India as a global arbitration hub because that shows that you have more institutions at every city, at every nook and corner, and your matter will get resolved under the aegis of those institutions properly. So, as an international, for a person who wants to, take it from outside the ring or understand from outside the arbitration Indian ring, will understand that no, India is a good power, is a good global arbitration power to come up with. So, yeah, that's something.
Now, sir, you've completed, and as I pointed out, I mentioned during your introduction
Mhm.
that you've pursued your master's BCL from the University of Oxford, and a very prestigious Ivy League university. And then you did not stop there. You went on to pursue and hold a PhD degree from National Law University, Delhi. So, how have your experiences been at these top universities, and how have they helped them in shaping your stellar career in arbitration?
A lot of interviews happen where I'm asked the same question, and I always have one answer, Jay. And you will probably relate to it, having heard it from a lot of people who've done their masters from Oxford, Harvard, all best universities. And I say this with some, I'm conscious of what I'm saying, at the cost of some of the Indian institutions not liking what I say. Is that I always believe that when you're, and especially when I did my masters in Oxford, it teaches you better focus. I'm not saying some of the national universities are brilliant. I'm not saying otherwise. But I always felt that my one-to-one interactions, and in Oxford there was a specific one-to-one which we call, which basically is a single one-to-one class interaction, a non-class interaction with literally the the doyens of their fields, their legal fields. I was doing a restitution. I was doing the courses that Oxford provided. The professors who were teaching will give you a one-to-one interaction after. This is called one-to-one tutorials, as we refer to it in the Oxford category. Now, imagine me sitting across the doyen of his or her field and them teaching me the law and answering my queries, discussing with me. And these are proper substantive discussion. There's not a 1 minute hello, hi with a cup of coffee and thank you very much. No. So that is something which I always feel those interactions were par excellence. And I never, uh, you know, comparatively, I never thought any institution could have offered it. And coming to PhD again was a strenuous procedure to work because I was doing it while I was working. So, completing my PhD, provided me with a, uh, I would say, deep and comprehensive understanding of the legal intricacies and practice in the area that I was mastering at that point of time. And it's an academic journey, like your masters, like your law school. It's an academic journey, so it hones your research and analytical skills. But what you do in PhD is what you're presenting your views as no one else has. You are proving your hypothesis in your field. So when you want to do that, the only way you can do it when you have good research and analytical skills, and that's what you better. That's what you enrich while you are dealing with the it's not just dealing with the challenges in court. It's when you've had those research and analytical skills working for you earlier through PhD, for example, that's what, you know, uh, makes you better at dealing with those challenges. You're arguing complex issues, and sometimes you need the legal precedent for that. Now, if you have good research skills, if you have good understanding ability of what you want, as a proposition, as a precedent for you before the court, that is where I believe that my PhD definitely assisted me. So this is BCL, PhD, any course for that matter, FCR, all these courses are designed to make you better in not just the field that you want to work, but also to make you more focused from a academic point of view, especially if you want to do litigation, I feel. Yeah.
So, to all the viewers who are watching valuable insights coming in from our amicus for today's session, it is very important to understand, especially to the all these young lawyers and law students, that once you enroll yourself with bar council, you start practicing in a court of law, you start doing jobs at top firms. It is very important to understand that your academic journey, academic stint should not come to a halt. It is very
Mm,
important to pursue these academic courses, to evolve and to remain updated as well. Otherwise, that is one problem that I've always seen, that lawyers stop pursuing courses on the
yeah,
academic front especially when they start practicing law. So,
correct.
you know,
I
that,
think that's very well put. I think you've absolutely hit the hammer on the nail, because that is something which all people should actually endeavor. They shouldn't stop. They should carry on with what they're doing. It's not. It's a learning curve for life. That's the profession that we've chosen.
Hmm.
So yeah.
Because the first question that pops up, unfortunately, is, and whenever I've had a conversation with any of the young lawyers and law students, is
Mm,
that how will it benefit us in practice, in the practice of it?
yeah.
So benefits are not necessarily remunerative. I mean, it could be the experiences
That's
that you've had, the enrichment that you've been through, the value addition that you do. So
mm,
all that, the one-to-one contact and the interactions that you've had with
mm.
professors. So that's, as so you rightly pointed out. So all these are definitely going to help you, evolve as better professionals in law.
Definitely, definitely. In fact, Jay, just to build on what you're saying, because that excellently elucidated by you. This was propping up with me in the earlier years when I did my masters. The clients or some of even my close colleagues came up to me and said, "You did BCL. Now what? I mean, you're the same lawyer as me or anyone else." Of course, that's true. I'm the same lawyer. BCL doesn't change me as a lawyer. I'm still the same person arguing in the courts. But today, the knowledge that I've gained, the focus that I've gained, and more importantly, when you come up to a client meeting, you're sitting across the table and telling your client that I've done this course, which had only at that point of time there were about 7 people only that were selected in the institution there, from India. When you're discussing all these aspects, it does give you an edge. It does definitely give you an edge compared to others. When you're dealing with a client or when you're in court, Mr. Bajpai and Dr. Bajpai will not change Bajpai, but Mr. and Doctor will definitely get you a different consideration, either with a client or with a court. It gives you that, like you pointed out, nobody wants to do the academic journey. Why? Because it is stressful. You're already working, and then you're all simultaneously doing all that. So it shows the courage that you've undertaken to actually go and proceed with it while working, which may affect you. So you've put in more hours, you've put in more efforts, and that's what differentiates with you. Every lawyer, with all due respect, and with all due respect, I have several of my friends and excellent counsels in court who have not done that. So this is not a comparison. I am not saying somebody who's done it definitely has a better launch pad, to proceed with his career in litigation specifically. Yeah.
And lastly, sir, you've been a tremendous source of inspiration to me and many. What advice would you give to someone looking to build a successful career in arbitration?
I don't think how inspirational I am. Very thankful to you for those kind words, yeah. But I've said this in some of my earlier interviews as well. I always ask my, juniors, my colleagues, people whom I'm mentoring, and to, in fact, any, student or lawyer, fresh lawyer, or even 10 years lawyer, have 4 points. It's a four-pronged approach. First and foremost, you have to establish a solid foundation. I did through my work in law school, I did through my BCL and PhD. You have to master the fundamentals of law to provide a sturdy base for a career. Now, I'm doing arbitration, that's fine. But if I don't know the Contract Act, if I don't know the CPC, if I don't know the Act, my fundamental principles are not there. And if my fundamental principles are not there, I can't proceed further. So that's number one. Number two is what we talked about, something which we call continuous learning. You commit to a lifelong experience of learning. It's not about staying updated, or you have your case which has one set of facts and one set of law. That does not preclude you from studying the other segments, and especially in a field like arbitration, which is constantly evolving. It's extremely dynamic. So this is something which you need to continuously do. And this also, when you're taking up courses like PhD, the masters, or any other FCR, or all these courses, they help you in that continuous learning. They keep your mind occupied in a better position, rather than sitting before the idiot box for 3 hours in the night. It's not going to help you. And that's number two. And three is something which I refer to as mentorship. You need to find guidance. You need to seek out mentors who will offer you insights and who will give you opportunities for growth. It may be before the court, it may be your senior in whose chamber you're working, it may be any godfather that you deem fit, but it has to be at least in the first few years. Then, of course, you're better suited to understand all those aspects. But at least at the initial stages, you must find guidance. You should not be full of yourself thinking that, I can do it on my own. Of course, you can do it on your own, rightly so. But guidance it never had a downside. I've taken guidance. As I told you, my PhD came literally a few minutes. The thought of PhD came. I've always thought of PhD, but like that impetus for doing it came with a few seconds, a minute's discussion with Dr. Singhvi. So, you don't know where you get that guidance from. So it's imperative for you to seek it, because if you don't seek out, you'll not get it. It's that simple. And last is more, I would say, uh, particular and pertinent to an arbitration setup. We need to explore, and I say this to everyone, we need to explore the ADR training, the alternative dispute resolution, mediation, arbitration, conciliation. All these are different categories. These are not litigation. Does not come within the ambit of litigation. So you need to understand, especially at the earlier days, if you want to practice in areas, consider specialized training in these methods. If there are specialized training like CR, for example, I'm on the core committee of the YMG group. Now, CR offers so many arbitration courses, so many construction arbitration courses. Same with SCL, the Society for Construction Law India. It offers courses. You go to conferences, you go to seminars. That's where you'll get accumulated. It may not happen on the first day. It will happen maybe a year or 2 years down the line. But trust me when I say this, you do all this and you will become better. You may not become the best, but definitely better than what you already are. And in the end, just be patient and persistent, and don't be discouraged by setbacks or challenges. Remember, we talk about legal career. The legal career is a journey, boss, and each step, whether big or small, will contribute to your growth and expertise. You will not know that at that point of time. You will do that 10 years down the line. Every This is a more colloquial way of putting it. Everyone has heard about it. It's water. Now, a drop of water hitting a rock, you will not realize its effect today. You will realize its effect when it's completely inundated that century or 10 years down the line. Single few drops of water. So every work that you do today and every step that you take towards building your career will help you ultimately in a manner that you will reap the benefits later. You reap as you sow. Seek that advice, work in training, and be patient and persistent, and keep on hitting pieces out. And definitely, maybe 10 years down the line, I'll be taking interviews of so many of our younger colleagues who have established that practice. Yeah.
Very well, sir. Thank you so much for taking our time and for doing this extraordinary session for us. Really means a lot to me and my team. Well, this month, particularly September, has been extraordinary for the virtual Amicus. A
Mhm.
couple of weeks ago, we had the opportunity to interview the Doyen of Mumbai arbitration bar, Mr. Behel, and now we had the opportunity to interview the Doyen of arbitration law from Delhi, Dr. Shashwat Bajpai. So really means a lot to all the viewers who are watching. Our email is mentioned on the channel. Feel free to write to us in case if you still have any queries with respect to the topic that we've chosen, which is the game of arbitration. The next episode is on its way. It's goodbye for now. Thank you so much, sir, once again.
Thank you, Jay. Thank you for having me over. Take care. Bye bye.